Hello, and welcome to a new edition of High Profile. My name's David Ryal, and I'll be your host for the next hour. This is going to be a totally different program than what John Kurt and I have produced for you over the past couple of years. When we talk about high profile, we've looked at some of the high profile organizations that are here in the county or some of the high profile services that are available to you. However, what we want to do in this show is to present to you a high profile that impacts each and every one of the residents in this community. And to set the tone for that, we'd like to start our program with a musical rendition of the Star-Spangled Banner.
For our national anthem, Miss Julia Galloway. Please stand for our national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Welcome back. Producer John Kurt and I felt that with what's going on in our nation at this time, that we wanted to make a program that focused on a document that you're always hearing about. You hear about the Constitution, or you hear that something's unconstitutional. Debates go on, and yet it doesn't matter what program you listen to, what side of the political spectrum they're on. They never cite, nor do they read the Constitution of the United States. they make commentary about it. So for the next hour, John and I would like to share with you the Constitution with some historical background, just very little commentary, and let you listen to the Constitution being read and words being shown on the screen. We are grateful for the Library Distributors of America for the production that we're going to be sharing with you, not only in this program, but in the next program. This is basically going to be our first two-parter. And so sit back, relax. You're going to be introduced to the preamble of the Constitution. We want you to pay attention to the first three words, "We the people," and the first six words, "We the people of the United States." And so with that, we'd like you to pay attention for about the next half hour. We're going to cover the preamble and also Article 1.
We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Thus begins the foundation of the United States of America, what the country and its people are built and survive upon. It is a remarkable instrument which has for over 200 years assured Americans freedoms enjoyed in no other country in the world. It has been the beacon others sail for, the shores they strive to reach, the ideal. Americans celebrate July 4th as the birth of the nation, the signing of the Declaration of Independence, which in actuality set the 13 colonies up as sovereign states, in essence, nations unto themselves. Those 13 colonies then bound themselves together to fight for their freedom from British rule, then headed by King George III. The success of that Revolutionary War then saw the states foundering, in danger from all other countries and rules, unless they bound themselves together truly as a single force. Observing what was happening to the very directions each state was going in, George Washington wrote,
"Something must be done to avert the humiliating and contemptible figure we are about to make on the annals of mankind."
Others, in addition to Washington, including James Madison, John Hancock, and James Monroe, were also concerned. After several fits and starts to bring all the states together under a single government over the years, during which rebellions of one sort or another sprang up in individual states, the Confederation of Congress, a near impotent body at the time, called for a convention in Philadelphia, Pennsylvania, for the specific purpose of revising the Articles of Confederation. This gathering was set for May of 1787. 55 delegates from the various states met and agreed that the Articles of Confederation must be set aside and a single nation constructed as a replacement. This has become known as the Constitutional Convention. For 4 hot months during that year, those delegates debated, argued, and compromised. Some left. Some did not even attend. Rhode Island was the single abstainer, so in truth, representatives from only 12 states contributed to the formation of the Constitution. In the end, there were 40 men who had seen it through to the end. Those 40 men are considered to be the founding fathers of this country. Most of these men were versed in the writings of political philosophers throughout history. All were knowledgeable of the various tyrannies of governments, monarchies, and dictatorships throughout history and the world, and knew that this country did not desire any of those, and all sought the same objectives: freedom, unity, and equality of a lasting nature. The extraordinary document that is our Constitution is truly a living one. The men who hammered it out over those historic 4 months 2 centuries ago provided a government with checks and balances to keep a rein on power, so that the bulk of power, which they believed to be the greedy root of desire which attracted tyrants and dictators to feel compelled to conquer, could not fall into the hands of any one individual person or any single branch of government. Furthermore, the framework of the Constitution is constructed so that at its very base are the people, the populace of the nation, who ultimately control the direction of the country. Often it is seen those in elected office forget, but it is the people who put them there, and the people who can also remove them. Usually they discover that after they have been removed by those people. The Constitution is remarkable also in that it is flexible, able to be altered, or in the formal sense, amended, to adapt to the changing times without the structure itself being weakened. Hence, some of the amendments which have come about over the years, the last amendment being ratified or approved as recently as May 18, 1992. This, 195 years after the original document came into force. Even after the men had forged this document, it was not readily accepted. It had to go to the individual states for their approval. In that respect, the Constitution was already working, even before it had been declared an actuality. No matter that some of the states' leaders balked at acceptance, a majority of the people of 9 of the 13 states approved it, and those then as now are the ones it was constructed for and who control it still. On many issues which face the nation in this latter portion of the 20th century, the Constitution is vague. How could those 40 men know of such conditions that would come to exist, such as nuclear armament, environmental concerns, air and space travel and exploration, so many things which face the populace today as were not even dreamed of 200 years ago? But still, the Constitution is supple enough, as long as its people are watchful, to accommodate the rising problems. The Constitution laid out by the Founding Fathers as a blueprint for the United States consists of 7 articles setting up and describing the 3 branches of our government: legislative, Congress, the Senate and House of Representatives; executive, President and Vice President; and judicial, the court system. Their duties, their powers, and limitations of powers, and the checks and balances they felt so necessary to keep the country and the power evenly balanced for the good of all, preventing any one or any branch from becoming too powerful and thereby falling into the pits of monarchy or dictatorships other governments had fallen into and which they had so recently fought their way out from under. Following the Constitution proper, there comes 27 amendments, the first 10 of which is considered to be the Bill of Rights, which was necessary in getting the Constitution ratified by the people immediately following the drafting of the Constitution in Philadelphia in 1787. It is laid out thusly. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every 2nd year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years, and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states which may be included within this Union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. In its original terminology, those bound to service for a term of years was applicable to apprentices and indentured servants, a practice brought over from England, and the 3/5 of all other persons referred to slaves. The passage in this section was changed by the 14th Amendment, which was adopted in 1868. Continuing with Section 2 of Article 1, the actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. These numbers of representatives was only a temporary provision and is superseded by congressional reapportionments based on each decennial census. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. The original conception by the members of the Constitutional Convention of 1787 was for the House of Representatives to be of a democratic nature, with the Senate detached from popular control, therefore the phrase, chosen by the legislature thereof. James Madison and James Wilson argued that senators should also be elected by the people, but the majority were opposed, feeling it unwise to give the people so much power. It was finally determined that senators would be elected by their own state legislatures, a practice which was in effect from the time of the original writing to 1913, when the 17th Amendment was adopted, allowing the people to vote in their own choices for the Senate, and thereafter causing that section to read, elected by the people thereof. Section 3 goes on to read, immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the 2nd class at the expiration of the 4th year, and of the 3rd class at the expiration of the 6th year, so that 1/3 may be chosen every 2nd year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. The 17th Amendment also modified this section dealing with the filling of vacancies in that it empowered state governors to fill unexpired senatorial terms which should occur. The remainder of Section 3 remains unchanged from 1878 and continues to read, no person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers, and also a President pro tempore in the absence of the Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not exceed further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time, by law, make or alter such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall, by law, appoint a different day. The first Monday in December was changed by Section 2 of the 20th Amendment, adopted in 1933, to read, "The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the third day of January, unless they shall, by law, appoint a different day." Section 5. Each House shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner and under such penalties as each House may provide. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or, being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. The checks and balances come into play here. While it seems ornately slow for bills to pass, the Founding Fathers felt it better to be slow and deliberate rather than hasty, rash, and eventually sorry something got through that shouldn't have. Any bill that seems questionable to one branch or the other must be returned, changed, or amended to fit the requirements of all branches, and each branch should be listening to the people as to how they should vote a bill or amendment. And further, the people should be listening to what is going on in these branches so that they can make their views on a particular piece of legislation known to those who are casting the deciding votes. The checks and balances were placed so that no single branch, like no single person, could usurp all authority and/or power. Section 8. The Congress shall have the power to lay and collect taxes, duties, imports, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imports, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States. To regulate commerce with foreign nations and among the several states and with the Indian tribes. To establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. To establish post offices and post roads. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. To constitute tribunals inferior to the Supreme Court. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. To declare war, grant a letter of marque and reprisal, and to make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. To provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states, respectively, the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. The Constitution has given each House of Congress separate special powers. The power to originate bills which involve the raising and spending of money was given to the House. The acceptance or rejection of presidential appointees to executive and judicial offices rests in the Senate. In addition, ratification of a treaty must be done in the Senate by at least a 2/3 vote before becoming operable. Impeachment of members of the executive and judicial departments for treason, bribery, or other high crimes and misdemeanors is the right of the House of Representatives, while the Senate acts as court to try these cases where a 2/3 vote is required to find a defendant guilty. One interesting section of the Constitution reveals the Founding Fathers to be not only wise but cautious, thoughtful, and perhaps prescient. That final paragraph listing the powers of Congress is known as the Elastic Clause. It allows Congress to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. It's as if they knew they could not specify all that the Congress of the future would need to deal with in the ever-changing world, but they realized things such as nuclear weaponry, defense mechanisms, flight, would have to be dealt with and provided for it with this clause. Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importations not exceeding $10 for each person. This opening paragraph of this section was made obsolete on January 1st, 1803. It was at this time that Congress prohibited all further importation of slaves to the United States. It did not, however, mean the end of slavery. That was not abolished until the adoption of the 13th Amendment in 1865. The privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. No bill of attainder or ex post facto law shall be passed. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. Congress first passed an income tax law in 1894, but the following year, 1895, it was declared unconstitutional by the Supreme Court because it was in violation of this provision. Since the only way to overrule a Supreme Court decision is to add an amendment to the Constitution, Congress in 1909 put forth an income tax proposal. It took 4 years, but it was ratified in 1913 and became the 16th Amendment, and reads, "The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration." This was the first of 4 amendments which were ratified during the period between 1913 and 1920, which are termed the Progressive Amendments. They were given that term because they reflect the spirit of reform which was moving through the United States during that period. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another. Nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the Treasury but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports except what may be absolutely necessary for executing its inspection laws. And the net produce of all duties and imports laid by any state on imports or exports shall be for the use of the Treasury of the United States. And all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay.
As you can see, the legislature of our government, Congress, the Senate, and the House, are responsible for a lot of the aspects of what takes place in our nation. Congress is the one that in our original document is given the authority to make taxes and to generate the revenue for the federal government. Next, we're going to begin with Article 2, and we're only going to cover Part 1 today. Our next session will pick up with the rest of Article 2 and the remainder of the Constitution. But Article 2 deals with the executive branch, i.e. the President and the Vice President. So again, hope you have maybe a pen and some paper and taking some notes, because this is your Constitution. You may not have read it since government class in high school, or maybe when you're in college. So it may have been 30, 40 years since you were familiar with your document. Again, remember, our government is based upon we the people. And now sit back for Article 2 of the Constitution.
Article 2, Section 1. This was perhaps the most vexing branch of the government for the founders to come to terms with. All the men in Philadelphia that heated historical summer of 1787 well remembered the dictatorial royal governors during colonial days and the overbearing King George III. They realized fully that this office, more so than any other in the new governmental setup, could be the one to turn a lesser man's head and thoughts to power and lead him into becoming a tyrant. They realized it would have to be a special and strong man to fill this office, and they argued long regarding the terms of this office. Some preferred a term of 27 years, which was, at the time, the normal reign of kings of the old worlds and the governments which most of them were familiar with. Others proposed a 7-year term. 4-year terms were finally settled upon, and it has remained that to this day. It was also proposed that they have 3 presidents serving at the same time, ensuring a balance. This was decided against when presupposing the inevitable clash of ego this would bring. The mode of election, term length, powers, and manner of election were given extra care and caution. 60 ballots were required before there was an agreement on how a president would be elected. At various times, it was proposed that state legislatures, governors, the people themselves pick the president. With the people being so spread out at the time as to leave them totally uninformed about a candidate, many of them illiterate, into the bargain, the latter was ruled out, as were the other 2. It was James Wilson, a delegate from Pennsylvania, who proposed the system which has come to be known as the Electoral College. The votes would be counted, with the person receiving the largest number of votes being president. Second largest number would be vice president. Each state legislature set up its own manner of choosing electors. Either they did it or allowed the people to do it. Today, every state chooses its own electors, who then cast the official votes. Article 2, Section 1 is set up thusly. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years and, together with the Vice President, chosen for the same term, be elected as follows. The original writing of the Constitution did not provide a number of terms one person could hold the office of President. The 22nd Amendment, adopted in 1961, was brought about after Republicans pushed it through Congress in 1947 and was prompted by Democratic President Franklin D. Roosevelt, having previously been elected to the office for a 4th term. This Amendment 22 states, "No person shall be elected to the office of President more than twice, and no person who has held the office of President or acted as President for more than 2 years of a term of which some other person was elected President shall be elected to the office of the President more than once." But this article shall not apply to any person holding the office of President when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of President or acting as President during the term within which this article becomes operative from holding the office of President or acting as President during the remainder of such term. Which basically means, for example, Lyndon B. Johnson could have run for 2 terms as president on his own should he have chosen to do so and been elected, since he served less than 2 years of John F. Kennedy's presidential term after the latter's assassination, whereas Gerald Ford served more than 2 years of Richard M. Nixon's presidential term after Nixon resigned from office with the threat of impeachment hanging over him. Ford, in his situation, would only have been eligible for a single term had he been elected in his only unsuccessful bid with his own campaign. Section 2 of the amendment reads, "This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress." Continuing with Article 2, Section 1. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. This section was also extended by the passage of the 23rd Amendment, which states, Section 1. The district constituting the seat of government of the United States, specifically referring to Washington, D.C., shall appoint in such manner as the Congress may direct a number of electors of President and Vice President equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of President and Vice President to be electors appointed by the state, and they shall meet in the district and perform such duties as provided by the 12th Article of Amendment. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. Up until this time, D.C., the seat of government, and the people living there could not vote for president or vice president, being a federal district and not a state, with no House of Representatives voting members and no senators, therefore no electoral votes. D.C. now has 3 electoral votes. The next paragraph of the Constitution, as originally written by the Founding Fathers, provided for a single election, with the person receiving the majority of votes being named president and the runner-up vice president. But this was before there were political parties. In 1800, with the emergence of the Democratic-Republican Party, Thomas Jefferson and Aaron Burr tied the electoral vote. The election was then decided by a vote in the House of Representatives, which elected Jefferson president and Burr vice president. Amendment 12 was then proposed and adopted in 1804, which put the president and vice president on separate ballots, each to be elected separately. The 12th Amendment superseded the original paragraph in the Constitution and reads, "The electors shall meet in their respective states," extended by the 23rd Amendment, "and vote by ballot for President and Vice President, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as President, and in distinct ballots the persons voted for as Vice President. And they shall make distinct lists of all persons voted for as President, and of all persons voted for as Vice President, and of the number of votes for each, which lists they shall sign and certify and transmit, sealed, to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for President shall be the President, if such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest numbers, not exceeding 3, on the list of those voted for as President, the House of Representatives shall choose immediately by ballot the President. But in choosing the President, the vote shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a President, whenever the right of choice shall devolve upon them before the 4th day of March, which was changed also by Section 1 of the 20th Amendment to noon on the 20th day of January, next following, then the Vice President shall act as President, as in the case of the death or other constitutional disability of the President. The person having the greatest number of votes as Vice President shall be the Vice President, if such number be a majority of the whole number of electors appointed. And if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the Vice President. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States. Here we go back to the original writing, Section 1 of Article 2. The Congress may determine the time of choosing the electors, and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of the President. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. This paragraph was also affected by the 12th Amendment passage, but no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States. Continuing on with the original, the President shall, at stated times, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States.